rise if you put down this, and I'll look at Mike Kelly presiding.
All right, good afternoon. Please be seated. Welcome back. I understand that Mr. Claypool would like to participate by phone. Is that correct?
Yes, Your Honor.
Okay. We had an email earlier that there was a problem with the phone system. I hope it's been rectified. We'll see. Mr. Claypool?
Yes.
This is Judge Kelly in Palm Beach County. How are you?
Good. Happy New Year.
Same to you. Okay. We have a status check in the Dippolito case. Let me start. I know there was a motion filed with respect to pretrial release, but I want to address the primary issue that I set this for, and that is scheduling of a retrial. I need to ask a couple questions before we get started. Is the defense intending to renew its motion for change of venue?
Yes, Your Honor.
Okay. Are you intending to file...
Your Honor, Brian, this is Brian Claypool. I haven't spoken to Mr. Rosenfeld about that, so I'd rather not make a representation to the court that we are going to do that. So I apologize, but can we defer on answering that question?
You can defer on answering the question, but I'm going to set a deadline for answering the question because this case doesn't exactly turn on a dime, and I have to figure out when I'm going to be resetting it and where. And so let me ask, and you can defer also, Mr. Williams, if you wish. Would the state, do you know whether the state would be opposing a motion for change of venue?
Probably not, Judge.
Probably not. Okay. All right, well, let me talk about options, and then you can decide, and I'm going to set a deadline with respect to either renewing your motion for change of venue or filing a new motion. Would you be filing a new motion or just renewing your old motion?
It would be amended, Judge, in light of the second trial, but for the most part, substantively, it would be the same.
Okay. All right, well, here's what we're going to do, and I'm going to tell you what the various potential options are, but I do need to know where we're going to try this case, or where in terms of either in Palm Beach County or someplace else, because I'm not going to know exactly where the case is going to be moved to for some time yet, but I'll tell you where the possibilities are. First of all, in terms of my availability, the earliest, because I wasn't planning to try this case again, obviously, I've got other things set through the first 6 months of the year. The earliest I could try this case again would be April. I've got special set cases through April and after April, but April seems to be the month I could do it. Chief Judge Colbath is willing, if necessary, and my schedule does not allow, to try the case for me. So Judge Colbath's availability is a little different because he does not have an assigned docket. He's just the chief, not just the chief judge. He is the chief judge, so he has duties and responsibilities, but he doesn't have a trial docket. So Judge Colbath also is a possibility in terms of retrying the case. Obviously, he's familiar with the case. Well, hold on, Mr. Roseman. Let's go through all the options first before he starts speaking about any of those options. And so my first availability is April. I don't know Chief Judge Colbath's availability. I haven't specifically asked him. He's just indicated a willingness, if I need, because of my trial schedule, to try the case. If the case is going to be moved, the three options for a change of venue are Jacksonville, Orlando, or Tampa. I will not move the case south. It doesn't do us any good. So those are the three alternatives. You need to go to a like-sized county. Demographics have to be similar. So those are the counties that will be mandated, either Jacksonville, Orlando, or Tampa, if the case is moved. If the case is moved, as I said, it would either be me or Colbath that would try it, depending on schedule. If the case is moved, I have not yet decided whether we will follow the Goodman format and simply select jurors in the other venue and come back and try the case here, or whether we'll simply try the entire case in whatever venue we select. There are a lot of logistics involved in that, and I have to decide which is the least onerous, candidly, for the county and for the jurors. So I have to decide that. That has not been decided. One method, of course, would be the Goodman method, simply select a jury, bring them back, sequester them, try the case here. Another alternative is to just try the case in its entirety wherever we go. That will also depend upon availability of courtrooms and jurors in these target circuits, because I don't know what the availability is. I've not contacted yet the chief judge of any of these circuits because it's premature. So those are the options. In terms of the deadlines that I'm going to set, because I need to know this quickly, because I need to be, if we're going to change venue, I need to reach out to each of these circuits, find out who has an available courtroom for me, when they have available courtroom, could they do it in April, could they do it some other time, what the situation is in that particular circuit. So if the defense is going to be, I'm assuming the state's not filing a motion for change of venue, you're just not going to oppose one if it's filed.
Right.
Okay, so I'll set up the deadline this way. If the defense wants to renew or file a new motion for change of venue, it must be filed by January 13th. You've got a week. If the state intends to oppose that motion, I want your written opposition filed by the 20th. In other words, you'll have another week. And so by the 20th, I should have before me both a motion and the opposition. If there's no opposition, what I'm asking the state to do is immediately notify me that there's no opposition, because the sooner, if I'm going to change venue, then the sooner I can start looking into the various circuits, the better off we're going to be. If we're going to stay here, and I'm going to try to do it in April, I've got a lot of arranging I even have to do here to get jurors, to secure the big courtroom again, if that's where we want to try the case, although we could try it just as easily here. So all those are issues. So those are the deadlines, those are the possibilities. It's either me, Colbath, it's either here, it's Jacksonville, it's Orlando, it's Tampa. Those, and April's the first that I can do it. So, all right, anything on resetting the trial that anyone wants to say? Mr. Roosevelt, what do you want to say?
I think in terms of option two, if Judge Colbath was going to try the case, we would be moving to disqualify him based on comments made in sentencing. I believe he did step away before. I'm not sure exactly what happened when Ms. Sescaro was on the case. But
No, he didn't step aside before. I took over the division.
Yeah. Okay.
That's the only reason Colbath doesn't have the case on retrial right now, I mean, absent a motion, obviously, to recuse. The only reason Judge Colbath doesn't have the case is he's the chief judge, and I took over this division, and this was Judge Colbath's division. That's the only reason. And when I took over this division, the Goodman case would have been my case, and he just agreed to keep it and try it, so I didn't have to. And I had the civil case in Goodman, so I could have tried that case too, but he just agreed to do it. That's all.
Sure, but regardless, we would be moving to disqualify him if he were to take the case based on several of the comments made in the sentence.
Okay, well, that's an issue that we'll cross that. I understand. We'll cross that bridge if and when we get to it. I don't know whether I'm going to try it, whether he's going to try it, or at least attempt to try it. I don't know where we're going with that right now. First thing I have to know is there a request to change venue? And if there is, then I have to figure out where we're going to go. If the state's not opposing the motion, more likely than not, although I'm not committing to a ruling now, if the state's not opposing such a motion, I'll probably grant it this time around, given the fact that we've got additional publicity that basically has now saturated the county in South Florida. So more likely than not, if one is filed, I will grant it unless the state shows me some reason why I shouldn't. Okay, so anything else on schedule? That's all I can do for scheduling right now. I've got to know where you guys want to go. Or, you don't get to choose the venue, actually. You just get to choose whether we're going to do it here in Palm Beach County or not in Palm Beach County. That's all. And in terms of the method, I'm going to decide whether we're bringing the jurors back or whether we're going to try the case in the new county if we change venue. All right, so that all I can do with scheduling right now. I think the only thing else that's on the table is, I think defense filed a motion for change of conditions of pretrial release.
And just one issue, I believe Mr. Claypool has one scheduling conflict in April, if he wants to address that.
Yeah, Your Honor, Brian Claypool. Obviously I'll talk to Mr. Rosenfeld. I mean, my initial inclination is to have Your Honor handle this. The next retrial, you're intimately familiar with the case, and I think that would certainly move the case along a lot quicker. That said, I don't have a problem with April. I do have a commitment with my daughter, my little girl, who I have a trip planned with on spring break from April 10th to the 14th. So if possible, maybe setting it after the 14th of April, then we would, if Mr. Rosenfeld is fine with that, we would be fine after that point in time.
All right, look, at this point, Mr. Claypool, I really have no idea about availability of courtrooms out of county. I mean, all I can tell you is my first availability is April, and then I've got special sets starting in May and in June. So, it depends on, we'll have to make obviously, length of the trial. I don't know whether it's going to be the same this next time around, whether it's going to be longer, I don't know. But all those things, I'll make a note of that, Mr. Claypool, and do what I can. I don't even know when the courtrooms would be available if we were going to pick a jury outside of this county. Of course, I don't know whether we're picking a jury outside of this county yet, so we'll make those decisions once I know where we're going to be selecting a jury. Anything else on scheduling right now? And what I'm going to do is, I'm not going to even schedule a future event in this case until I get any renewed motion. By the way, let me do this. Mr. Roosevelt, if a decision has been made by defense not to move to change venue before the deadline that I've given to you, would you please let me know? In other words, you've got until next Friday, but if you all decide before then that you do not want to file or renew your motion for change of venue, if you would also, as a courtesy, let me know.
Absolutely, Judge.
Because even staying here, getting this case reset is, behind the scenes is a monumental task. So I need to know as soon as possible what I'm doing. So you've got till for next Friday, but if you know earlier, please let me know.
Yes, sir.
Okay, all right. So the only other thing I know that I'm aware of is that the defense had filed a motion to change conditions of pretrial release. So I'll hear that now, as long as it doesn't take too long, and then we'll recess. So, Mr. Rosenfeld, are you arguing that? Is Mr. Claypool arguing that?
Yes, I have one moment.
All right.
Your Honor, this is Brian Claypool. If you could ask Mr. Rose, or the counsel to possibly, are they near a microphone?
They're not. That's why you're not hearing them, Mr. Claypool. Yeah, the phone system is actually tied into the mics, and I'm speaking to the mic, they're not.
Okay, all right, no problem.
They will now.
Thank you.
Mr. Claypool.
Yes.
All right. We made some progress there, Judge.
All right, go ahead.
Yes, Your Honor, we've been moving to modify the conditions of pretrial release. As stated in the motion, Ms. Dippolito is not a flight risk. She is not a danger to the community. As Your Honor is well aware, but actually before getting into argument, Judge, if Your Honor would take judicial notice of a few things. One, the 3-3 split of the jurors in the second trial.
Well, I was there, so I know.
Well, just for purposes of
I'll take additional notice that we had a mistrial, and it was a 3-3 split.
And I did attach 2 articles, Judge, regarding the 2 alternates, if you take judicial notice of those articles.
Is there any objection to me taking judicial notice of articles?
I don't know how that's relevant to a bond hearing.
Well, you may be correct about that, Mr. Williams, but in terms of just procedurally, do you have any objection to him pointing out his belief that 2 alternates would have joined 3 voting for not guilty?
I don't know how that's a judicial notice.
I'm not sure it is. That's why I'm asking you.
It falls under there, so
I don't know how that falls in the category of judicial notice. It's not something I can judicially notice.
That's fine, Judge. But
Well, if there's an objection, I won't. Good.
And last, we'd ask you to take judicial notice of, and just to move this along quick, of all records from Ms. Dippolito's in-house arrest regarding her residence in the community. You can take judicial notice of that she is a resident of Boynton Beach, that her mother owns the house in Boynton Beach. Those are all things that Your Honor is permitted to take judicial notice of.
I'm not sure with notice I might, but they're not, I'm not sure those things are, well, it's, I'm not sure technically it's part of the court file, but nevertheless, I mean, Ms. Dippolito could testify to all of that
I'm just trying to
anyway.
move this along.
So it's, I don't know whether technically that's a matter of judicial notice, but I also don't think it's a matter of dispute. So I will consider those things.
All right, Judge. So just getting back to argument, I think it goes without saying that Ms. Dippolito is not a flight risk. She's not a danger to the community. As we just stated, there was a 3-3 split in the last trial. 3 jurors found her not guilty, 3 found her guilty. The state has been unable to secure a conviction twice now.
Well, I secured one conviction, but it was overturned.
Well, arguably, Judge, that's not securing a conviction when you have a tainted jury pool. And it coming back on appeal, I guess, indicates that it wasn't secured. But
The results of both trials they're both void. They're of no meaning at this point.
Yes, Judge, but I think it is reflective of, it does go to the weight of the evidence necessarily. When you have 3 members of the community finding Ms. Dippolito not guilty, that shows that this case is not as strong as the state has consistently presented it. Your Honor knows she is cloaked with the presumption of innocence. She spent roughly $19,000 on house arrest. She's been on the most restrictive house arrest for the past 7 years. She hasn't been able to leave aside from going to my office, going to the doctor's office, and going to church. For a while, she couldn't leave her house and couldn't go to her front patio. I know that was modified eventually. At this point, she does have a child, an infant. And this is, being on this restrictive house arrest is inhibiting her from, properly caring for her child. She's forced to rely on family. She's unable to do countless things that a mother should be entitled to do with her child. One moment, Judge. She's a 34-year-old mother. She's been a resident of Palm Beach County since 1996. Her mother owns the house in Palm Beach County, in Boynton Beach. This is all testified to at the initial bond hearing, so Your Honor is aware of this. She's resided there with her mother and her sister for 20 years, aside from a 1-year gap where she moved to California and moved back. Her mother continues to be employed for the healthcare industry for, I believe, 25 years now. I don't think it's fair to hold the fact that Ms. Dippolito is not employed because this court has prohibited her from being employed. If taken off house arrest, she will continue to live with her mother, with her sister. She has a brother who lives in Boynton Beach, a nephew that lives in Boynton Beach, a soon-to-be sister-in-law as of, I believe, March 11th, who lives in Boynton Beach. She has aunts and uncles in Orange County. She clearly has strong ties to the community that indicate that she's not a flight risk. More importantly, Judge, she had never been arrested prior to this incident. She is 34 years old and has never been arrested. This also goes to her not being a danger to the community. I think she's been or demonstrated exemplary conduct while on pretrial release. There was in 7 years one, which I'm going to call a technical violation based on the advice of counsel, and Mr. Eiglosh did speak to that. When she went to his office and did an interview, that does not indicate that she's a flight risk. It does not indicate that she's a danger to the community, and she did act in good faith based on what counsel told her. But for that, she would not have done that. So I would say she's been exemplary while on pretrial release. She's been actively involved with her church. She's become very spiritual over the past 7 years. And the purpose, Judge, of pretrial release is to protect the community and to ensure that she's not a flight risk. She is a public figure. Where is Dalia Dippolito going to go? Her face is known nationwide. I mean, at this point, it's punitive to keep her on pretrial release. She's cloaked with the presumption of innocence.
Well, all defendants are presumed.
Correct, Judge. But for her to have now served 7 years on house arrest for someone who's presumed to be innocent, for someone who is not a flight risk, is necessarily punitive. Just one moment, Judge. And I guess in regard to Mr. Dippolito, she's not a danger to him. He's been seen driving in the vicinity of her house in his white Porsche. I think if he finds her to be a danger, he won't be driving in the vicinity of her house. He's going to places where her mother's going. I believe restaurants, is that correct? Grocery stores. Yeah, I mean, she's not a danger to Mike Dippolito. This is an incident, an allegation from 7 years ago. And for those reasons, Judge, there really is no reason to keep her on on house arrest. She scores 4 years. And 4 years is not a large recommended sentence as opposed to a lot of bond modifications I've had with much more lengthy sentences. I do have some comps, Judge, if I can just grab those briefly.
And what?
Some comps.
Comps?
Where, where the fourth has, addressed. And I understand that all cases there are dissimilarities in all cases, Judge, but one moment.
Your Honor, Brian Claypool, just to add briefly while Mr. Rosenthal's looking at his notes, we would also ask if the court's disinclined to grant Mr. Rosenthal's motion for pretrial release to at least give some kind of modification to the current terms of house arrest to allow Ms. Dippolito a little bit more freedom during the day to spend time with her child outside of the house. So that's another option that verbally present to the court.
Yeah, I mean, Judge, if you look at, Stallings v. Ryan, 3rd DCA, 2008, bond was set at $910,000 initially for 102 counts of sexual battery on a child in 2 separate cases. The defendant was a 50-year resident of the county, and the charges were based solely on the statements of complaining witnesses. And the district courts ultimately held that bond should be set at no more than $100,000 on remand. He was not confined to his house. Calistro v. McCrae, 858 Southern 2nd, 1079. $50,000 was not unreasonable for a sexual battery charge where the defendant qualified as a 3-time violent felony offender and violent career criminal. Here we have a woman with no criminal history. Her criminal punishment score is 4 years. She's given no indication of being a flight risk, no indication of being a danger to the community. The weight of the evidence is not as strong as everyone thought based on the jury's finding. And I believe there's no reason for her to continue to be punished in light of the fact that she's presumed to be innocent, not a flight risk, and not a danger to the community. So if Your Honor is not inclined to grant our request, which is for her to be released on her own recognizance, not permitted to leave the state, her passport must remain forfeited, the no contact orders remain in effect, and that would necessarily rectify any concerns Mike Dippolito may or may not have. I think this court would properly protect the community, Judge.
All right, anything further before I hear from Mr. Williams or Ms. Lord? I'm not sure who's arguing. Ms. Lord?
Yes, sir.
All right.
Judge, the state obviously would oppose their bond modification for several reasons. I disagree with a lot of their arguments. Obviously, Ms. Dippolito was convicted and sentenced to 20 years, and I realize that their argument is that 5 people from this recent trial, 3 of the jurors and 2 alternates, have indicated that they would have found her not guilty. However, I would point to the 100-plus people probably in voir dire who repeatedly stated that based on the evidence they had seen, which was the evidence presented in this case, that they would have found her, that they felt that she was guilty and could not be fair and impartial. So when you look at the numbers, I think they are staggeringly different. She obviously, from what we now understand, has had a family. According to this motion, plans to get married.
That's on the motion, Judge. I'd object to that.
Well, she says that she's going to be gaining a brother-in-law, so I'm assuming maybe it's wrong.
No, I said her sister is...
Sorry, I
Your
apologize.
brother is getting married, excuse me.
I apologize. I misread it then, but I took it as her. Either way, she now has an infant child who I think anyone who has previously been sentenced to 20 years, it then increases the risk that if the thoughts that would presumably be going through someone's head, that if you're convicted of this crime again and facing a hefty sentence, you would be stripped from that child and therefore would increase the odds that someone would decide to take the risk and take off, increasing her being a flight risk. As far as she is on, as far as the monetary part, she is on a very reasonable bond. House arrest secures her presence in this court. I don't think that her mother's employment has anything to do with this. Her lack of criminal record, stating that it changes her flight risk, I disagree with that in a sense that I think that someone who is looking at and has previously been sentenced to a significant period of time in the Department of Corrections, it could increase that motive to flee based on a fear of going to DOC. As far as relaxing the conditions to allow her to do things with her son, there has not been any motions presented to this court to allow her to take her child to doctor's visits or anything else. As far as taking him out to play, based on their representations, he's an infant. I don't think that it's someone who needs to be taken to school or can go run around a playground. So I think it's just kind of getting into let's just go do whatever we feel like doing. Based on all those things, I think that there is plenty of reasons not to take her off house arrest. Obviously, house arrest is an alternative to someone being in custody.
I can just briefly respond.
Brief response.
First of all, when I referred to her criminal record, I was saying that means she's not a danger to the community, not that she's not a flight risk. Secondly, the 100 people who came in and made statements about Ms. Dippolito individually did not hear the evidence in this case. They did not sit through a trial. So for this court to even consider what 100 people had heard in the media, as opposed to what they heard from live testimony, is it is unfair, Judge. It's the weight of the evidence, and the evidence comes out of trial, not through the media. Furthermore, Judge, she does have an infant child. The state's correct, but she has no money. Where's she going to go? This court declared her indigent for cost, so she really has nowhere to go. I also forgot to mention before, she has never failed to appear for a court appearance. She's a prisoner in her own home. For 7 years, she's been a prisoner in her own home, Judge, and she's shown no reason for this court to believe that she's a flight risk or a danger to the community. And even if Your Honor does believe she is, I agree with Mr. Claypool. There are alternatives to ensure that she appear in court. She can remain on a monitor and not be confined to her house, that she has to remain in the state or remain in the county. And the court would then know where she is, so she could not flee the jurisdiction and have that freedom. And she could also not come within a certain distance of Mr. Dippolito's house, which he's currently not allowed to do when traveling to court, when traveling to my office, when traveling to church. So that would resolve all of the state's concerns about her trying to flee the jurisdiction.
Okay. All right. The only change in circumstances that really could be cited would be the the mistrial that we've had. And candidly, I don't, in terms of setting conditions of pretrial release, a mistrial is the same as the previous trial. It's a nullity. It doesn't really change anything. I'm going to deny the motion at this time. Now, with respect to modification of any conditions of pretrial release, what that will require, I'm not denying that outright at this time. I'm denying the request to take her off of in-house arrest. But in terms of modifications of conditions of in-house arrest, that has to be specific. It can't be generalized. So to the extent that the defense wants to file, as they have in the past, a motion which identifies specific activities which they believe should be permitted on in-house arrest, obviously providing the state with a copy of it, I'll be happy to consider those things and rule on those, but I don't rule in a vacuum, just generally speaking, on lifting restrictions. That has to be very specific, and instructions to the supervising officer have to be very specific. So I'm not denying that outright. I'm just saying you need to file a motion specifically identifying which conditions or what additional freedoms, I suppose you might put it, on house arrest you wish to have.
If I can respond to one thing you said, Judge, if I may approach the case law. And one of the biggest misconceptions, and Your Honor will not find a case saying otherwise, I have consulted with countless attorneys and have researched this issue for a long time, is that defense has to show a change of circumstance for modification.
I didn't say you did.
You said you've seen no change of circumstance.
I haven't.
Never said
I didn't say you had to prove it. I've said I've seen none. The only thing that's been really, the only difference since the conditions of pretrial release were set that's occurred would be the passage of time, which I would tend to agree with you has been a long time, and I'm going to try to rectify that by getting this case to trial so that it's resolved one way or the other. You're not required to prove change in circumstance. I just said I've seen no change in circumstance other than the trial you're citing to me, and I don't see any basis, just on the simple fact that we have a mistrial, to change the conditions of pretrial release. I don't think you do have a duty to prove change in circumstances. The state would if they were going to try to restrict you.
Yes, Your Honor.
The state would have that. I don't, and perhaps I chose my words poorly. You don't have that duty or responsibility. You don't have to show the case law to me on that. I understand that. I'm just saying the only thing that's changed is we've had one trial and a mistrial. That's probably the way it should have some understanding. I guess right now the ball is in the court of the defense in terms of deciding whether they want to file a renewed motion. And as soon as I know where we're going there, I'll tell you what we're going to do next. Just for clerk's purposes, this will not fall off the map, believe me. I don't have to set a future event right now. You will get an order from me setting the next special event, or trial or whatever we're doing. Okay, anything else?
Your Honor, know in advance, so you know my schedule. I am getting married in 15 days, so I'll be, unless you're going to set any special
I will not
hearings.
mess up your wedding, Mr. Rosen.
The bachelor party already.
I may have messed up your bachelor party, but I'm not going to mess up your wedding.
I have
Okay.
a scathing fiance, Judge.
Okay, well, I'm sure she's going to understand.
Your Honor,
Yes, Mr. Claypool.
Your Honor, Brian Claypool, just briefly, if we're able to get this motion to slightly modify the house arrest, if we were able to get this together and get it filed by Monday or Tuesday, would the court entertain having and obviously the state can respond, but can we have this heard before Mr. Rosenfeld leaves or gets married? I mean, I'd like to get this resolved one way or the other
I
within the
don't
next
see any
week or
reason
so.
why you couldn't. I mean, I rule on these types of motions every morning at 8:30, so I mean, I don't think...
Okay.
If it's going to take any more than 10 minutes, you might have a problem. I may have to set it at 8:15, but if it's not too lengthy and it's not going to take more than 10 minutes total, 5 minutes aside, I see no reason why
Okay.
we can't do it before then.
All right, thank you, Your Honor.
Okay, anything else?
That's all.
Okay, we're in recess.